start. It was also pleaded in the said application that disputes, if any, could not be classified as maritime dispute, attracting applicability of clause 60 of the agreement between the parties, and the agreement dated 4/12/2007 does not fulfill the ingredients of an arbitration agreement as prescribed in section 7 of the act. Stop. The aforesaid application, however, was not decided by the arbitral tribunal, which was of the view that on the first date of hearing the claims should be decided and adjudicated. Stop. This was followed by 3 more applications before the arbitral tribunal seeking a decision of the issue of jurisdiction, competence, and validity of the arbitral tribunal. Stop. The arbitral tribunal, however, decided to proceed with the matter without giving decision on the applications filed by the petitioners. Stop. Being aggrieved from the order of the tribunal dated 5/7/2013, deciding to proceed with the manner the petitioner is before this court seeking quashing of the aforesaid order, besides a direction terminating the mandate of the arbitral tribunal. Stop. The petitioner before this court, on receipt of notice from the arbitrator, raised a preliminary objection with respect to maintainability of the arbitration proceedings inter alia on the ground that there was no arbitration agreement between the parties. Stop. The arbitrator wide imposed order dated 15/6/2017 rejected the preliminary objection of the petitioner. Stop. Being aggrieved, the petitioner is being this court seeking quashing of the aforesaid order dated 15/6/2013. Stop. In contending that the arbitral tribunal is required to decide the issue of jurisdiction as a preliminary issue before taking any further pleas in the arbitration proceedings, the learned senior counsel for the petitioner in WP number 6328/2013 laid emphasis on the words where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceedings, and make an awards used in subsection 5 of section 16, and submitted that ignoring the aforesaid mandate of law is likely to visit the parties with consequences of having to suffer in terms of the wastage of time and incurring huge costs. Stop. If at the end of arbitral proceedings the tribunal was to hold that it had no jurisdiction in the matter. Stop. He further submitted that right to appeal conferred by section 37(2) of the act in the event of the tribunal exceeding the plea of want of jurisdiction or exceeding the scope of its authority as the